Chauvin update. The trial has begun. Jury selection is completed. And what's the status? We have a full panel of jury. We have a full panel of jury. 14, 2 alternates. Have they been impaneled yet?
They end up impaneling a 15th one. So they come in to be formally take the oath tomorrow morning, and opening statements are tomorrow. And opening statements will probably take up the whole day. And so because of the nature of this case, it is expected to go 4 weeks, about 6 hours a day of trial testimony. That's pretty normal for state court. Some state courts are even shorter. Federal court, you often go 8-10 hours. Though this judge is a little bit on the longer side. What I think, given all the motions in limine have been determined, now from a jury pool perspective, it is the prosecution thinks they got the jury they wanted based on demographics, is my read. That the jury pool, a typical jury pool would be mostly white, would be about half white men. It would only have 1 to 2 minority members out of the 15 on it, based on Minneapolis's and Hennepin County's jury pool. Instead, what they have is 6 minority members of the jury, very few elderly. So it's a young millennial leading. So demographically, by polling data, it's a conviction-oriented jury. And many of their statements pre-trial were statements that I think most people would interpret as leaning towards guilty. Robert Grueller at the Watching the Watchers, also he has a locals page, watchingthewatchers.locals.com, and he's one of the people we interviewed for the Sidebar show on Wednesday. Great life story, empowering life story of what he's overcome to achieve where he's at, and why he cares about the things he does. But he did a breakdown. He thought it was about at least 8 to 9 jurors lean guilty. And I think that his analysis was pretty, I would have put it more at leaning guilty is the only difference. Now, my view is the leaders of the jury, if whoever the foreman is, will tell us a lot. If it's that social media seeking juror, the second juror seated, then I think Chauvin is in trouble. If it is an African-American male juror that ends up being jury foreman, particularly one that I have in mind, it may be at least a partial acquittal jury. So the defense clearly believes, based on individualized information that they know about each of these jurors, that they think a lot of the particularly African-American male jurors may be a acquittal-oriented jurors on 2 of the 3 charges, on the most serious charges, including counts that are more serious than the ones than Chauvin was willing to plead to. And so that's the jury update. So the opening statement, all the evidence has now been ruled on for the most part in the motions in limine stage. Go ahead.
Oh yeah, I was going to say, just to remind everybody, or to inform those who weren't watching last week, the biggest evidentiary ruling was allowing history of George Floyd's, not prior criminal history, but rather prior incidents wherein apparently he attempted to consume drugs in order to avoid or evade arrest type thing. One, in the last time it landed him in the hospital, it was 2019. So that's going to be admitted, and Chauvin's prior history will not be admitted as evidence. That's accurate?
Exactly. So the prosecution's, I think, opening statement will focus heavily. We'll see what if I was them, I would include everything, but they may try to only include part of the video. We'll see. But their storyline is going to be accenting the time in which Chauvin is on the back of George Floyd, and to some degree on his neck, and that there's some dispute about whether it's on really the upper back or the neck in terms of where his hold is. But their focus is going to be on the time period that's taking place, and that while that's taking place, they're going to emphasize that other officers were saying we probably should flip him over, that prior training in Minneapolis said that when they're no longer resisting, flip them over, that a paramedic not a paramedic, but someone who works in the fire department who was there at the scene was telling him to flip him over, that someone that knows MMA was saying, based on where his hold was at the scene, telling him to flip him over. So they're probably going to accent warning after warning after warning after warning, and Chauvin ignores them all and Floyd dies. So that will probably be the core of their story. They won't get in Chauvin's history, and we'll see if they try to deal with, in anticipation, the defense. A smart prosecutor will do so, but some of them are so arrogant and live in their own world that they refuse to do so. And so we'll see if they're smart and try to anticipate certain defenses that are going to raise and try to preempt those defenses. The defense opening statement is likely going to be focused on that evidence that was introduced, that was declared to be introduced last week. And their story is going to be what happens as Floyd gets pulled over. He has a bunch of contraband on him. He has fake currency on him. He just committed a crime at the local store. He has illicit drugs on him. And when this happened before in 2019, almost a year to the date in Minneapolis, what did he do? He tried to hide the evidence and buy time. And he did so by not complying with police all the way through so he could try to get rid of the evidence. He tries to get rid of the dollar bills. They're later found crumpled in the car. He later tries to get rid of the drugs. They'll show a picture of him with what appears to be something in his mouth that could be fentanyl. They'll show later that in the car they found parts of fentanyl spit out or lost with his saliva on it. And they'll show the toxicology report that showed he had an extraordinarily high lethal dose of fentanyl in his system at the time of death. And they'll talk about how their medical experts will have concluded that the knee on the neck had nothing to do with the cause of death. Their secondary aspect of their defense will be that this is consistent to his training. And they'll show photos from training manuals, including training they borrowed from Israel and other places, such that these are internationally recognized standards where this is the norm. I don't know if they'll get into data, because this part was not clearly ruled on prior to trial that I saw. But if they did, they would get into hundreds of people this detention had been used on, and of them, none of them. It was not uncommon for them to pass out, but so it wouldn't be unusual to see a person passed out underneath you. But it was none of them had ever died before. So Chauvin's experience was this was proper training, this was proper protocol, seen it utilized multiple times, done it himself. A smart defense lawyer will try to introduce his client's testimony through opening statement in anticipation of what his client will testify to, even if he decides ultimately never to have his client testify, because it's a way to get that story in advance. Johnny Cochran gave one of the best opening statements and one of the best closing arguments ever in the O.J. Simpson case, which will be a future broadcast on the innocence of O.J. Simpson for the murders.
We might have to get Dershowitz back on for that particular episode. Say one silly question, I think. The whole counterfeit bill. Like, I don't know how that works. Is it alleged that he had it by accident, or that he was part of a counterfeit ring and he was trying to launder the counterfeit money into currency? Like, is that known how he came in possession of the counterfeit bill?
Not that I know of. Not that I've heard as yet. So just that he had it, that he passed one at the store, and that he had two more on him and tried to crumple them up, and it's why he's not putting both hands on the wheel. That he's and they'll focus. The other third thing they will focus on heavily is the whole interaction, the context of the 2019 interaction with the 2020 interaction, so that when Chauvin shows up, what the other police officers have been dealing with is someone who's refused to do anything, has refused to comply, won't put two hands on the wheel, won't get out of the car in a timely manner, won't get into the car, won't stay standing up, keeps falling down. Once he's in the car, is being disruptive and trying to not be in there, says he's suddenly claustrophobic and can't do it. And that he's saying he can't breathe before he's even ever on the ground. So that context will be a radically different context than what most of the jurors will have ever heard before.
I have no doubt that the jurors are going to learn information that they have no idea even exists. Like, they would not be able to contemplate some of the information they're going to hear. I'm sure of it. Are they going to plead the issue that Nate Brody covered it on his channel, Nate the lawyer? There was another case out of Minneapolis, virtually identical from what I understand to this case, where someone passed away after a knee using the Minneapolis standard protocol as per their website and training, and was acquitted. So, I mean, at what point do they plead precedent, and what power does precedent have in a case like this?
Usually none. It may come in through, if they're smart on the defense lawyer side, through cross-examination of the government's experts. The government will have law enforcement experts that will say our training said not to do this. They'll have medical experts that say the cause of death was what Chauvin did. Defense will have experts that say, no, this conduct was consistent with his training, and they'll have medical experts to say, no, it wasn't the cause of death anyway. If you're smart on the defense side, you will try to get into evidence through one of the government's experts. If they say, hey, training was A, B, C, and D, to say, isn't it the case that courts have recognized as part, and that what you would do is a cross-examination like this. You recognize as part of training, as customs and practices, as recognized by court decisions. Try to get them to say yes. Isn't it the case that a Minnesota case, an 8th Circuit Court of Appeals case, said that a 15-minute neck hold was not unreasonable force as a matter of law in the months leading up to this case even happening? And that would be the way you would try to sneak it in. Judges usually try very much to keep it out, thinking it's more prejudicial than it is probative. And so that's an open question. We don't know what the expert witness looks like, testimony looks like. We don't know what some other aspects. Some of that will likely be previewed. There'll probably be a very technologically sophisticated presentation because this is highly unusual prosecution. It's mostly being prosecuted by private lawyers, by some of the top trial lawyers across the country and appellate lawyers across the country, all coming in to weigh in against one guy and one defense lawyer. So the resources is definitely a mismatch, but certain facts don't change. And some of those facts point more towards acquittal, at least of the top 2 counts. And I think, of course, there's legal problems with those counts too. But my guess right now, if I was a betting, there probably will be betting markets on this. My first bet on a legal case was that O.J. Simpson would be acquitted. Made nice little cash on that when I was a young fellow.
Oh my God.
I'm not saying whether I had a client maybe bet on felony acquittals in his case, but if he did, hypothetically speaking, he made a nice little cash cow on that. But that's another story for another day. But if there is, my odds, I would say 50% chance of conviction on either of the top 2 counts, 75% chance conviction on the second-degree manslaughter count. Just because of the jury pool. If it turns out this really was an impartial jury that was really open to the evidence and not worried about the consequences of their verdict, then I would say 25% chance conviction on the top 2 counts and only 50% because the causation issue applies to all 3 counts.
Someone asked who's paying for Chauvin?
The police union.
Okay, and who's paying for the prosecution, bringing in private counsel to prosecute? I mean, it's a stupid question, but obviously taxpayers.
Yes, indeed.
All right, and then I was reading up on this also that one of the other big decisions, although it's an older one, was not to change venue. And from what I was reading, the refusal to change venue in the event of a condemnation could itself be substantial grounds for an appeal. So, I mean, do we see that happening in the event of a conviction, that they're going to invoke the grounds that there was not a change of venue, that the jury felt pressured by virtue of the climate to condemn or to convict?
Yes, it's just not a very strong ground after the Enron decision of the U.S. Supreme Court. Once they could try the Enron defendants in Houston, your ability to get a reversal for failure to change venue is very, very low. What you need is the kind of polling data, that someone like Richard Barris, the People's Pundit, I utilize him for those kind of cases to show. You need data, you need evidence, you need to create a real record. They didn't create anything close to that record here. So there's a lot of people inferentially can see the problem, and the judge was somewhat concerned with the problem, but they didn't create the kind of record that would make that a reversible issue. I think the top 2 counts, even though one of them was reinstated by the Court of Appeals, if the Minnesota Supreme Court enforces the law, the top 2 counts, if he's convicted on either of them, I think should be thrown out on appeal. And that may contaminate their conviction on the 3rd count. So they may never get anything affirmed. Chauvin himself, no matter what happens here, is kind of screwed because he's caught on a bunch of tax charges in the federal system. So, and in the state system too. So he's going to jail. He's lost his job. He's going to jail, prison, no matter what, going to be bankrupted no matter what. He's trying to avoid 40 years in prison. So his big thing is the top count. He was willing to plead to 3rd degree. That's 20 years. Typically you get 10. Usually you serve 5, something like that. He would probably get a harsher sentence just because of the nature of the case. But even that's manageable. Their real thing is to acquit him on the big count, the felony murder count.